Welcome everyone to this Privacy Rules Privacy Espresso. The episode of today is part of a series where we are going to discuss with our experts on the various EU regulation and regulatory framework we are witnessing nowadays, considering both laws that are already applied and laws that are upcoming. In this case, we are together with Beatriz Rodríguez, our member from the Spanish jurisdiction from the law firm RocaJunyent. Beatriz is a partner and also an expert in, of course, privacy and data protection. And what we are going to discuss with her is about one specific regulation that is called DORA. Beatriz, without further delay, I would like first of all to thank you for being with us, and maybe I can immediately ask you to give us an overview on what is this DORA regulation.
Thank you very much, Alessandro. Happy to be here as always. Well, it has a very impacting name, like operational resilience for financial sector. But as most of you are aware, resilience means the capability of recover very quick from difficulties, from problems that happening, and to be back into shape as soon as possible. And that's like the main intention of this regulation. It tries to uniform all requirements concerning security of networks and information systems for financial entities. We had some of these requirements in several directives and regulations within the European Union. Also, there were very high standards or very good standards for cybersecurity that they could comply or not, but weren't mandatory. And now this regulation established these all obligations and framework. It's going to be applicable from January 17, 2025. So we have yet a little time, to adapt and being able to comply. And the good news is that most of the financial entities in financial sector already had certain, of these requirements, because some other regulations or those standards required that, and they had to do this for the clients. The thing is that they weren't uniform for the whole European Union, and they were different strategies to be followed. And now all of this is unified, and it tries to keep, the main scope is let's ensure that our financial system is going to be able to continue functioning even though we are attacked, because cyber attacks are something that it's happening and it's a reality.
That's thanks a lot for this brief overview. That sounds as a very technical regulation that is going to require further implementation to just sectoral based companies. In terms of applicability and scope, I would be curious to know, this is EU law, but does it have effects also abroad for other companies, and how?
Well, it affects like financial entities in the European Union, but in a very broad scope. For example, of course, when we think of financial entities, we think of credit institutions, investment firms, payment institutions. But for example, it's also going to be applicable for data reporting service providers, insurance intermediaries, credit rating agencies, and of course, it's also going to apply to information and communication technology service providers in the European Union and outside the European Union, but that work with these financial entities. And it goes a bit further, and also even determines that it, for example, the regulation gives power to certain European authorities, financial authorities, to supervise and monitor these third-party providers and also their subsidiaries in other parts of the world if they have certain relation with the activities that they are providing for or the services they are providing for those financial entities. So yes, once again, this regulation establishes a very broad scope, not just for the European Union and not just for the typical financial companies we have in mind. It is good to know also that it establishes a proportionality principle. So for example, it moderates the obligations and the constraint depending on the size of the companies and the risk of the companies and of the capabilities, the scale, the complexity of operations. So it's not so constrained for all companies. It moderates the regulation, and that's good, because for small companies within the European Union, if not, it was going to be a lot to have in their minds.
Perfect. And in terms of let's say content of this regulation and requirements, which are the key parts and requirements that you think companies, or at least speaking also about the structure of this regulation, which are the key points and requirements you think companies should at least start from or have an idea of?
Well, it follows, like the route that the European authorities have been following since GDPR. So it establishes a governance framework and decided that it's necessary to appoint certain key figures within the organization to ensure that the framework is going to work. It also relies on the accountability principle and on the risk-based approach. So everything that is done, it has to be demonstrated by the companies and determined on a risk-based approach. And of course, should depend on the capabilities of each company and on the size. And then it focuses on risk management framework to monitor and, identify vulnerabilities, assets within the organization, and then protect and prevent the assets, and of course detect and recovery, from the incidents and from the problems that are detected. And also establish like a framework for management those incidents and report that within the European Union, and also gives an obligation to record not only the incident but also the cyber threats that are significant, and then it gives companies the possibility to share that cyber threats so that all European Union can be, updated and aware of what is going on regarding cyber attacks, which is something very, I think, intelligence, in order to be able to manage this in a more efficient way. And then it establishes a whole framework of third-party risk management for those providers that are giving services to that companies. And it creates like an oversight framework of authorities so that they can also develop framework and standards for contracts and help these third-party service providers to comply. And on the other way around, they can also be supervised, as I was saying before. So, they can be sanctioned if they don't comply with the obligations, and authorities like the European Securities and Markets Authority can supervise such providers and can inspect. So these are like the main, key points of the regulation.
Great. That's extremely useful in order to have a better understanding of what we are talking about. I just have one last question, but it's very specific to that. Is there any notification requirement in the law?
Yes, there are notification requirements for incidents, security incidents, depending on how big it is. If it's a major incident, you have to report it, and it complements the former reporting obligation that companies already had. So, for example, it gives like more concrete obligations regarding report for the authorities you already had to report, and sometimes it's established new obligations for reporting to other authorities that you didn't or weren't aware before. And also regarding third-party providers, you have to report their performance, and you have to report how are you managing contracts, and how many providers are you hiring each year, and the size of the provider, so that once all the reporting has been done, the authorities can determine which of that providers are critical, because a lot of financial entities depend on them, and depending on that, they are going to impose further obligations for such critical providers.
Perfect. Thanks a lot, Beatriz. And that's interesting.
You're welcome.
Because there is an additional layer of notification when there is a data breach. Yes. We were speaking with one of your colleagues on the Resilience Act, for example, where there are other requirements on notification. So this is getting more and more complex. So one more reason to be assisted, and probably to prepare to such kind of situation beforehand, because if you're not prepared, it's going to be quite difficult to handle a breach and report, right?
Well, it is true that the regulation has this into account and establishes the possibility of creating a hub, for incident response and trying to harmonize all these reporting obligations. So this is a quite interesting idea. It's not yet determined, because it says that the ESA shall make an assessment on this and decide how to proceed on this hub. But as they are aware that there are a lot of reporting obligations, maybe this is a way, to solve this.
Let's keep fingers crossed, because it sounds as a good solution, let's say. Beatriz, again, thanks a lot. We are running out of our time, so I wanted to thank you for being with us today, and also our audience for following us. I invite you and all of them to join us with our Privacy Espresso series. So looking forward to meet you all soon. Bye,
Thank
Beatriz.
you very much, Alessandro. Have a nice
Bye,
day.
everyone.
Bye.
You too. Bye-bye.